Thank you, Mr Chairman. It's a pleasure to serve under your chairmanship. I rise to move amendments 38, 39, 40, 41, 42, 43, 44, 45, 46 and 49 in my name and those of some of my colleagues. I also rise to move Amendment 10 in the name of my honourable friend, the Member for Central Ayrshire, and some of my other colleagues, and also to move Amendment 28, 29 and new clause 43 in the name of my honourable friend, the Member for Cumbernauld and Kilsyth. Mr Chair, we heard a lot yesterday from the benches opposite about the desire for the British people to get on with Brexit. And so I would like to begin today by reminding the benches opposite that the United Kingdom at present consists of 4 constituent parts, and 2 out of those 4 constituent parts, Scotland and Northern Ireland, have voted to remain in the European Union on every single occasion they have been given, including the European Union referendum in 2016 and thereafter. And whilst I acknowledge that the Prime Minister and his party won a majority of the seats in England and respect that outcome in England, I would ask them on the benches opposite to pause and consider that the Prime Minister did not win a majority of the seats in Wales. He didn't win any seats in Northern Ireland, and indeed it was Remain parties that won the majority of the seats in Northern Ireland. And in Scotland, where the Conservative and Unionist Party stood on a manifesto of delivering Brexit and preventing a second independence referendum, they were reduced to a rump of 6 MPs, and the Scottish National Party won the election emphatically. So I would just ask that perhaps this afternoon could not be another session of Scotland Get Back in Your Box, but there might be some respectful recognition of the democratic desire of my constituents in Edinburgh South West and the majority of constituents in Scotland to have remained in the European Union, and therefore, rather than lectures about delivering the will of the British people, let us seriously consider that it is the role of opposition to scrutinise bills. And while I realise inevitably Brexit will now happen, although I hope and believe that Scotland will find a way round that for Scotland, that doesn't mean to say that there aren't very legitimate concerns about the way in which the government are seeking to deliver Brexit. And I will, yes.
Will she further accept that 16.5 million people voted for parties either supporting Remain or a public vote on the deal, versus 14.5 million for the oven-ready Brexit that we've been prepared, and therefore there is in fact a democratic mandate to put this deal to the people still?
Well, I have to say that I think the ship has sailed on that because of the outcome of the election in England. However, the ship has not sailed on Scotland's constitutional future, because, like it or not, the Conservative Party was reduced to a rump of representation in Scotland in the general election, and my party won 47 out of the 59 seats. Now, it's surely a matter of concern in a democracy which is not a unitary state but consists of several nations, that no matter how many amendments I and my colleagues put forward to this bill, and probably every other bill in this session, we are unlikely to achieve a single amendment. And rather than the braying and jeering which occurred when the leader of my group, the Right Honourable Member for Ross Skye and Lochaber, got up to ask his questions this afternoon, I would suggest to those opposite, if they really believe in preserving the union of the United Kingdom, they might want to show a little bit more respect, not necessarily to me or my right honourable friend, but to those who sent us here to advocate for what the majority of people in Scotland want. And whether the benches opposite like it or not, the majority of people in Scotland do not want to leave the European Union, and the majority of people in Scotland want a second opportunity to look at Scotland's constitutional future in the light of England's decision to leave the European Union. I defy any Democrat to say that that's not a reasonable position. And I would just gently suggest to the benches opposite that jeering at the representatives of voters in Scotland shouting us down and rubbishing our legitimate concerns is not a sustainable position for the next 5 years.
Will the right honourable lady give way?
I will, yes.
I thank the right honourable lady for giving way. I'm a unionist, and yet I share her concern that there is a need for the voices from the various and diverse parts of the United Kingdom to be heard. And she is right to say that it is unlikely the government will accept any of the amendments that are being put forward today that represent very legitimate concerns, not least on the part of those of us who represent Northern Ireland, and actually who have come together in a rather unprecedented way, all the main parties, to back many of these amendments. So I do hope going forward, post the withdrawal agreement, that there will be more consultation and more discussion, including the representatives of the various parts of the United Kingdom.
There's not much about which myself and the right honourable gentleman will agree, but we can agree on this point. And there needs to be a recognition in the triumphalism of the win in England, and I understand that, because we feel pretty triumphal about our win in Scotland. Yeah. But in the triumphalism of the Conservative Unionist Party's win in England, if they really say that they are a Unionist party, then they require to engage properly with the representatives of the other parts of the United Kingdom. Now, this brings me to the terms of the amendments I wish to move today. And just before I get on to the amendments number 38 and the ones associated with that, I just want to raise again with the Treasury bench the points I made yesterday about the sweeping powers which the government is taking to itself in clauses 3, 12, 13, 14, 18, 21 and 27 to make delegated legislation making provision for areas of devolved policy. Now, I know the Secretary of State tried to rubbish my interventions yesterday, but if he's had time to read the independent report of the Scottish Parliament Information Centre overnight, he will see that this is not some SNP party political diatribe, but it is a matter of fact on careful analysis of the bill that the government is taking to itself the right for British ministers acting alone to make delegated legislation in relation to devolved areas. And this shows that the paragraph, which the SNP have complained about on a number of occasions, is actually going to take place. Now, the Minister tried to deflect me yesterday by saying, first of all, that the power related to reserved matters. Simply not correct. It quite clearly relates to devolved matters. And then he tried to say that the power they were taking was simply technical. But of course, the Minister will know that the Sewell Convention doesn't apply to delegated legislation. But, Mr Chair, it probably wouldn't matter if it did, because the government is prepared to drive a coach and horses through the Sewell Convention now. But rather interestingly, the government's delegated powers memorandum in relation to this bill states that the UK ministers won't normally make regulations in relation to devolved areas without the agreement of the relevant devolved administration, which is what the Sewell Convention says. But we know that lately Sewell and that convention has been more honoured in the breach than it's being obeyed. So I want to ask the Minister again, can he revisit his remarks from yesterday? Will he acknowledge for the record, and these are matters which of course may be litigated in the future, so the record might be quite important, will he acknowledge for the record that the clauses to which I've referred do give UK government ministers the power to make delegated legislation in relation to devolved matters? And will he acknowledge for the record that that is an incursion into devolved policy, which rightly causes concern, not just for the Scottish National Party, but for all those who believe in the devolved settlement? And I know it's history, but 22 years ago, 75% of the people of Scotland voted for that devolved settlement. And it's worth remembering that the background against which they did so was years and years of Scotland voting Labour, but getting a Conservative government. Now we have years and years of Scotland voting SNP, but getting a Conservative government. And I think it's quite reasonable, if one looks at history, to draw the lesson from that, that there probably will be another constitutional referendum in Scotland soon, because a similar tension exists as to the tension which existed in the 1990s. So I look forward to hearing from the Secretary of State later on today with an acknowledgement of the power that is being taken to the British Government here.
Well put.
Now, overall, Mr Chair, I would say that what this bill is about the Executive taking as much power to itself as possible, not just from the Scottish Parliament and the Welsh Assembly, but also from this Parliament, with the swinging use of delegated legislation, and in relation to Clause 26, which I'll come to in a moment, from the judiciary. Now, the Conservative and Unionist Party's manifesto revealed that the Government's aim was to change the balance between Government, Parliament and the courts. And as my honourable friend, the Member for Central Ayrshire, said yesterday, in this bill we see the beginning of the changing of that balance. But we also see a continued attack on rights, not just the undermining of EU citizens' rights, as we heard yesterday, not just the undermining of workers' rights, which we'll come to later today, but also the rights of child refugees. And I think it's fair to say that this is the proposal in this part which we're discussing just now which has excited the most public comment. And I've certainly received many communications from constituents who are very worried about this. And in this connection, I wish to move the amendments in the name of my honourable friend, the Member for Cumbernauld and Kilsyth, new clause 43, Amendment 28 and Amendment 29, or at least to address them at this stage, Mr Chair. Whether or not they're moved is perhaps a matter for later. Because, Mr Chair, right now, across Europe, there are thousands of unaccompanied children living in the most desperate circumstances, many of whom are separated from their families. And legal family reunion is a lifeline to these children who would otherwise risk their lives in dinghies or in the back of lorries in order to reach a place of safety with their family. And we've seen some pretty awful evidence recently of what can happen when refugees resort to dinghies or the back of lorries. And in recognition of that fact, in 2018, a cross-party coalition in this House, including prominent members of all parties, including the Conservative and Unionist Party, recognised the humanitarian need for family reunion to continue and secured a legal commitment from the then government to negotiate a replacement for it for the rules currently in place when we leave the European Union. And for the government to seek to remove those protections now risks causing panic amongst refugee families currently separated in Europe with potentially tragic consequences. And it's also deeply unacceptable to constituents of many different MPs in this House. Now, the government say they're going to continue with refugee family reunions, so it's really not clear to me why they're going to the trouble of taking the commitment out of this bill, unless they want to hedge their bets a bit. And based on past experience, that's what I suspect they are up to. Because without this obligation in the bill, there will be no obligation on the government to ensure that family reunion continues beyond the very restrictive rules in United Kingdom law. I will, yes.
To the Honourable Lady, and I was one of the supporters of the original amendments around family reunification, and I trust the government that this commitment will be stuck to in the appropriate place, which is an immigration bill. But will she acknowledge that there is a potential problem post-Dublin III with the full extent of those family members who qualify for family reunification, which needs to be sorted out? There's also a problem with the rate at which potential applicants are processed in places like Greece and Italy, which is not working well, and the cost of those applications as well. This whole scheme needs to be properly overhauled, and just bunging it in this bill is not necessarily the best way of getting the best result, which we all actually want.
The answer to that is the whole scheme is not bunged in this bill. The obligation to maintain certain minimum level requirements is being taken out by this bill when it was agreed on by cross-party members, including the Right Honourable Gentleman, in the last Parliament. And the UK's immigration rules as they stand, apart from some very limited circumstances, only allow for children to reunite with parents in their UK. only allow for children, not other relatives, just children, to reunite with parents in the UK. I've just finished the point and then I will. Under the EU Dublin III regulation, children have a legal route to reunite with other family members such as siblings, grandparents, aunts and uncles. And 95% of the children that the charity Safe Passage supports to reunite with family safely and legally would be ineligible under the current UK rules, the consequence being that they would be forced to remain alone and separated from their family. So there's a very legitimate concern that taking out this previous commitment in this bill is the beginning of a move towards an absolute minimalist requirement, minimalist approach from this government to their rights and duties. And I give way to the honourable gentleman.
Just to put on Hansard and on record the issue of what the honourable lady has referred to. In my constituency, there are many churches, there are many individuals, there are lots of people who have contacted me by email who want to see that what the honourable lady has asked for enshrined in the legislation. I had thought that perhaps maybe government were committed to doing that, and it is disappointing. But I'm just saying that if government wants to reflect public opinion out in the street and wants to reflect the public opinion in the constituency of Strangford and elsewhere, then listen to the voices of the churches, listen to the voice of the community groups, listen to the voice of individuals who want to see it happening. And with that in mind, I would support the honourable lady.
Grateful to the honourable gentleman for his comments, with which I entirely agree. Now, the amendments that have been have been crafted by the SNP, I just want to deal with them and then I will take another intervention. New Clause 43 is designed to oblige the government to negotiate an agreement so Dublin III as a whole continues as closely as possible to the current arrangements. So far as we can make out, this is different from other opposition amendments which focus only on children with family here. And the purpose is to challenge the government to explain why the broader Dublin III system is not worth saving. Amendment 28 specifically relates to children. Again, so far as we can see, unlike other opposition amendments, it's the only one that goes beyond seeking an agreement and requires ministers to put in place a scheme so that we keep accepting take-charge requests from unaccompanied minors. We in the SNP ask, why should that be negotiated away? If we believe children seeking international protection are best placed with their families, then let's allow it to happen in the United Kingdom. If we get an agreement that the arrangement is mutual with the EU, that would be great. But why wait? Are we seriously saying that in the unlikely event that the European Union decide to play bad cop, Britain, global Britain, won't take these children? And I give way first of all to the honourable lady from Manchester, which I forget, and then to the...
And following very carefully the argument she is making, would she not also agree that the obligation the government already has under the 2009 Act to protect the best interests of children would be an essential factor in considering exactly the amendments that she is discussing, and that if they're refusing to accept these amendments, they are undermining that piece of legislation and the intention of it?
I do entirely agree with that point, and I'll take an intervention out of the right honourable lady.
I'm for giving way. But just you also agree that the thing that is so troubling about what the government has chosen to do is they've chosen to remove the obligations in the previous 2018 Act that everyone had accepted, that had been supported by government ministers, by this House, as just a very sensible objective to negotiate an agreement to make sure that some of those vulnerable children could simply be reunited with those families. It was the most innocuous element of that Act, and so therefore it is just inexplicable that government ministers should suddenly decide they want to take that away.
I agree, it is inexplicable unless government ministers see the advantage of the majority they have secured for the English electorate to renege on an important humanitarian commitment, which, as the honourable member for Strangford said, represents the best about what people across these islands hold dear in terms of their Christian faith or other faiths or their humanitarianism. So I think it's incumbent upon the government to tell us what they're really up to here. Now, if I could just deal briefly with Amendment 29, I'll just make a little bit of progress now. Amendment 29 is similar to the ones advanced by other opposition parties, and it simply puts back in the obligation to negotiate an agreement for unaccompanied children. We see that very much as a fallback, Mr Chair, and we would like this House to go further than that. Now, I want to move quickly on to deal with my amendments number 38 and following, which relate to the extent to which this bill resorts to delegated powers in order for the government to change the law in the ways it feels are appropriate, not necessary, but appropriate, in relation to our withdrawal from the European Union. Because this bill enables the government to make potentially huge changes to the law through secondary legislation, which cannot possibly enjoy the same level of scrutiny by this Parliament which one might expect in a properly functioning constitutional democracy contemplating such significant change as this Parliament seems determined to embark upon. Now, in the previous Parliament, I pressed ministers to explain why the determining factor for the use of these extensive delegated powers was whether ministers felt them to be appropriate rather than necessary, because appropriate sets a very low and subjective threshold, enabling the minister to implement a wide range of legislative measures without adequate parliamentary scrutiny. And many independent bodies, such as the Law Society of England and Wales, along with other bodies such as the Lords Delegated Powers and Regulatory Reform Committee, have suggested, as my amendments do, that the test should be narrowed to an objective test of necessity. Because, Mr Chair, if the role of Parliament in scrutinising this delegated legislation is going to be reduced, then the only other mechanism to scrutinise it will be through judicial review. And that puts quite a heavy burden on the individual. Now, in the previous Parliament... Yes.
Thank her for giving way. She's making a very important point here. And I sat in many of the delegated legislation committees in the previous Parliament, and your ability to actually amend anything is nil. You can't amend anything, you can't change anything in delegated legislation committees. So would she agree with me that it's a woefully inadequate process because there is no prospect? Well, it might have some degree of scrutiny, it certainly has no ability to change anything.
Yeah, I mean, my honourable friends are absolutely right. And the reality is that if the only place where this discretion is going to be scrutinised is in the courts when individuals raise concerns about the impact of delegated legislation on their rights, then the breadth of discretion which the judiciary have to determine whether something is appropriate rather than necessary could be quite problematic for the judiciary, and indeed that was reflected in the previous Parliament by judicial concerns about the breadth of discretion afforded by the word appropriate. Now, I've tried on numerous occasions in the previous Parliament to get ministers in the government to explain why they must have the word appropriate rather than necessary. But I'm not a quitter, Mr Chairman, so I'm going to try again today, and I'll be interested to hear what the Minister has to say. Moving on to Amendment 10, in the name of my honourable friend, the Member for Central Ayrshire. I believe she's going to speak about it later, or may wish to intervene in me, but I'll just deal with it fairly briefly, but it's very important, and others will of course speak about Northern Ireland at length this afternoon. But Amendment 10 deals with powers in relation to implementing the Northern Ireland Protocol, and as my honourable friend, the Member for Central Ayrshire, said yesterday, the arrangements in relation to the Protocol are pretty sketchy, with almost everything left to the Joint Committee to work out, and then to be enacted again through delegated powers. But there's a significant difference between the restrictions on the powers afforded under new Section 8C and those under previous similar sections, such as Section 8B5. Because there's no restriction on the powers, for example, in relation to their ability to impinge on the devolved settlements of Scotland and Wales. And there, of course, are very live concerns about the extent to which business organisations, food and drink industry, and particularly inshore fishing, as we heard yesterday, could potentially be impacted upon in Scotland in relation to the Northern Ireland Protocol. And I give way to my honourable friend.
I'm grateful to my honourable friend for giving way. I mean, the issue obviously also includes the Northern Ireland Act, and of concern perhaps in this chamber is the Human Rights Act. if you look at the clause that new clause C would replace in the Withdrawal Act 2018, it had the limitations. They had become relatively standard, and I find it very suspicious that they are missing. There is no sunset clause, there is no restriction about taxes or new offences, and particularly no protection for the devolved administrations or the Human Rights Act. I think that is really concerning, because we are being asked to sign up to something that we have no idea what the long-term ramifications are.
And as I think a committee of the House of Lords pointed out, it's very unusual for restrictions in relation to the Human Rights Act and also the Scotland Act, the Government of Wales Act and the Northern Ireland Act not to appear in relation to delegated powers. So I'm interested in hearing from the Government as to why these restrictions don't appear, and as to in what ways they think the implementation of the Northern Irish Protocol will impact upon the Scotland Act and indeed the Government of Wales Act, and in what ways the implementation of the Northern Irish Protocol will impact upon the Human Rights Act, and why they therefore want to take to themselves delegated powers to interfere with the Human Rights Act and the devolved settlement in Scotland. Now, looking quickly to my amendment in relation to clause 26, which is number 49. This relates to the concern expressed by many that the government is amending section 6 of the European Union Withdrawal Act, the original provision being that the Supreme Court for the whole of the UK, or in relation to criminal matters, the High Court of Justiciary, were not bound by retained EU case law and could depart from that case law in the same way that those Supreme Courts would depart from their own case law. But in an almost, I think I'm correct in saying, an unprecedented use of delegated legislation, in clause 26, the government intends to take to itself the power to pass regulations specifying additional courts or tribunals that could depart from EU law. Now, that's a most unusual approach, and I'm wondering what has prompted this approach. I'm interested to hear what is the justification for clause 26. Is it an act of revenge on the Supreme Court of the United Kingdom and the Supreme Court of Scotland for daring to defy the previous Conservative government for ruling its unlawful prorogation out of order? Or is there some other rationale for this? If so, I'd be very interested to hear what it is, because I know their lordships are taking a very close interest in the other place in this clause, and even if I'm not able to move the SNP amendment to this clause today, which would revert to the status quo of the previous Act, I'm sure it will be moved in the House of Lords, because there's a very real concern that the aim here is to impact upon the independence of the judiciary, and that also different regulations applying to different courts about the extent to which EU law was overruled or could be applied will interfere with the very important principle of legal certainty. So again, in some ways this is a probing amendment, but it's an amendment which, if not moved in this House, I'm sure will be moved elsewhere, and so it would be interesting to hear from the Government exactly why they consider it necessary to change diverge so radically from the previous course of action upon which they were determined. Now, before I conclude, Mr Chair, I know there are a number of other important amendments in this section laid by other parties. I want to say something about them very briefly. Amendment 4 from the official opposition on child refugees is one which we would be inclined to support if they move it, although we would like to go a bit further than that, as I indicated in relation to the amendments I mentioned earlier. Also, amendments from the official opposition in relation to transparency on the arrangements for Northern Ireland, and generally on scrutiny and oversight, we are very keen to support. And we are also wholeheartedly give our support to the amendment laid in the name of the Honourable Member for Brighton Pavilion, and also to our friends from Plaid Cymru, new clause 17. And also, Mr Chair, it is of course a great pleasure, particularly for myself and my colleagues in the SNP, to have once more in this chamber the company of Irish nationalists. And whilst I totally respect and understand Sinn Féin's historical reasons for abstentionism, it's good that we will again hear the voice of Irish nationalism on the floor of this House, and the voice of a very significant part of the community in Northern Ireland, and will be reminded that Northern Ireland, like Scotland, voted to remain in the European Union. So we would be keen to lend our support to the amendments laid in the name of the MPs for the Social Democratic and Labour Party. So in conclusion, Mr Chair, I know and I'm certain that not one single amendment sponsored by the Scottish National Party will pass in relation to this bill. Just as one single amendment sponsored by the Scottish National Party passed in relation to the Scotland Bill back in 2015, despite the fact that we had 56 out of the 59 MPs in Scotland and now have 48 out of 59. It's worth remembering that the devolution settlement, which this bill will undermine, was predicated on the idea expressed in the Claim of Right for Scotland, which asserts that it's the sovereign right of the Scottish people to determine the form of government best suited to their needs. And of course, on the 4th of July 2018, the previous Parliament unanimously endorsed that principle in the Claim of Right. So the previous British Parliament accepted that it's the sovereign right of the Scottish people to determine the form of government best suited to their needs. This means that this House has itself recognised the principle of self-determination for Scotland, explicitly and unanimously. And I'll look forward to seeing whether the Government have any proposals to reverse that in this Parliament. But what I would say to them, returning to what I said at the opening of my remarks, the day is coming when the people of Scotland will once again vote on whether Scotland should regain its former status as an independent nation-state. And the hubris, insouciance and lack of respect for democracy embodied in this bill will hasten that date and ensure victory for the independence movement.
For clarification, and as the Honourable Lady indicated, although a very considerable number of amendments and new clauses have been grouped for debate under this part, only the lead amendment at this stage is moved. So the question is that Amendment 38 be made. And it gives me pleasure to call, by way of a maiden